Ms. Brommel.
Thank you, Your Honor. May it please the court, opposing counsel. My name is Becky Brommel, and I represent the appellants in this case, Edward and Susan Cox. Edward and Susan Cox are a married couple who, at all times relevant to this proceeding, have been residing at Westview Care Center in Indianola, Iowa. They were both born in 1950 and thus turned 67 years old in 2017 and were over 65 years old when the relevant events to this case took place. Both Edward and Susan have numerous health problems that have rendered them physically disabled and prevented them from being able to live on their own. At what I consider to be a relatively young age of 65, both Edward and Susan expect to live the remainder of their life in a nursing facility. Susan's disability arose from an event of medical malpractice for which she received financial compensation. As a result of the malpractice, her husband, Edward, also received compensation for loss of consortium. After paying off debts and paying back medical expenses, the remainder of these funds were placed into separate special needs trust established with the Center for Special Needs Trust Administration, which is a nonprofit association. I think it's first important to understand the type of trust that we're talking about here because it is a very specific and special kind of trust. These special needs, are often what are referred to as pooled trust, are governed by specific provisions in federal and state law. In order to qualify as one of these trusts, then a nonprofit has to serve as the trustee. The funds are set up into individual sub-accounts for each respective participating individual. And the center, who acts as the trustee, is required to distribute funds in accordance with the trust documents. The statutes also require that the trust documents contain certain provisions. One of those provisions is that the funds must be solely used for the individual's needs and cares. Numerous provisions in the particular trust documents that Edward and Susan joined contain these provisions.
Counsel, if Warren Buffett put all of his assets, and he's in his 80s, I think, into this trust and moved into a nursing home, could he get Medicaid?
Not if he's not disabled, and I don't think Mr. Buffett would consider himself disabled. So
work with me. Let's say
yes.
Somebody with his wealth who is disabled. What same result that you're seeking?
There has to be other things in place. I mean, the trust, if he signed similar trust documents to what exist here, then yes. And the reason for that is because one of the other requirements that's important that these trusts have to have is that Medicaid can obtain the funds that are left in this trust once the individual dies. So it's sort of, I would describe it as sort of the Medicaid can get their recovery on the end, while it allows these individuals who are disabled and who likely need more care than what Medicaid can provide to utilize those resources during their lifetime.
Did the 8th Circuit and South Dakota Supreme Courts decide the same legal issue that is presented to us here today? The two cases that you're referring to are the Center for Special Needs Trust versus Olson, and then there's the South Dakota cases, Enri Pooled Advocate Trust. They were slightly different for a couple of reasons. One is, and we think that they were wrongly decided, of course, but the court specifically only looked at, in the 8th Circuit case, they were really focused on subsection C of 1396P of the federal statutes. It's 42 U.S.C. 1396P, subparagraph C. Sorry, there's a lot of statutory information. If we followed those cases, and I realize you don't want us to, and
right.
You say they're wrongly decided, but if we followed them, do you lose?
I don't believe so. I think there's a couple of reasons for that. In the Olson case, the 8th Circuit case, the court there did not get to the fair market value arguments, which is the second reason we believe that Medicaid eligibility should exist here. The court focused solely on that subsection C, made a quick decision that if you're over 64, if you're 65 or over, you have that ineligibility period. They did not get to the second piece of that, which is to assess whether that deposit or transfer into the trust is for fair market value. The court did not get there.
What value did the Coxes get in exchange for their transfer of those nearly $500,000 into the pooled trust?
So what they get is, obviously they have the trustee monitoring those funds, and just like any trustee, that services that people would receive on the open market for monitoring or use of your funds. The other item that they get in exchange is those items can only, according to the trust documents, that money is intended to be and is restricted from being used for anything except for fair market value. It's also restricted from being used for anything that would lead to Medicaid ineligibility. So it can only be used for items that can be supplemented by private pay. So there's supplementation statutes, both in the Iowa Code and in the federal code, that allow even people on Medicaid should be allowed to pay for these things, whether through other family funding or other type of funding. These are very basic needs: telephone, personal comfort items, reading materials, things of that nature. Those are the types of things that this be utilized for. And so the courts that have looked at this, there's been a number of lower courts that have looked at this very issue of fair market value and found that by putting that money in the trust, they are getting the value of the items they eventually purchase. There's no requirement that everything be purchased up front.
Is the fair market value determination a question of law or fact or mixed?
Well, I think it's a question of law as to whether it applies, first of all, and we believe it does, and we believe there's been many cases that have said you should get to that fair market value argument. But it then also becomes a question of fact in terms of, does this particular trust meet those requirements? And I think that's where, with the South Dakota case, they found in that case that the deposit itself was not fair market value, but the differences there were that the trust had not shown what types of purchases it intended to make, and also the trust documents didn't guarantee that those funds would be used to benefit the beneficiary. Whereas here we have specific provisions in the trust that say these can only be used to benefit the beneficiary, and they have to only be used for items in fair market value.
But it still strikes me that if we put aside this attempt to sort of satisfy a Medicaid requirement, if we put that aside, aren't you better off if you just have the money than if somebody else has the money, subject to various restrictions, and if you die before that money is used up, you don't get it, and so forth? Now, aren't you really better off? Don't you have more value if the money's completely in your hands and fee simple, so to speak?
I would say not. First of all, it prevents you from being able to get Medicaid funding. That's how Congress set this up.
That's a sort of circular argument.
Right.
I mean, the Medicaid, the whole concept of the statute is, I assume they're looking at fair market value without the impact of the Medicaid restriction in order to determine if the Medicaid restriction applies. It's going to be circular if you factor that restriction into it, right?
I think you still get the fair market value of, as many of the lower courts that have looked at this issue have said, you give that money over, it's the same thing that you would be able to use it for if you were on Medicaid and you could buy supplemental items. So it's restricted to those items that you could buy otherwise, even as a Medicaid participant.
Let me go to kind of the statutory interpretation. The basic piece is, I read this 1396 PC2, I think that's what we're looking at. It says, an individual shall not be ineligible for medical assistance to the extent that the assets, and then there are four possibilities, were transferred to the individual spouse or to another for the sole benefit of the individual spouse. That doesn't apply. Transferred from the individual spouse to another for the sole benefit of the individual spouse. That doesn't apply. Were transferred to a trust for the benefit of the individual's child. That doesn't apply. And then the last one is, were transferred to a trust established solely for the benefit of an individual under 65 who's disabled. That doesn't apply. So it may be a harsh result, but reading the straightforward language of the statute, I think I agree with CMS. Tell me where I'm wrong.
Well, you have to move forward to there's another category that says the transfer, even if we agree it is a transfer, which that is our first argument, is that we don't believe it, that C even applies because D captures the entirety of these trusts. But if that were to apply, there's another provision that talks about that the transfer does not cause ineligibility if it's for fair market value. So there's a whole nother section that you would have to assess. You don't just assess those three very specific ones. You also then go on and assess the more general category of fair market value.
Correct me if I'm wrong, but you're saying C doesn't apply because D captures everything?
Yes, so basically the argument is that D, because it's, and the title of it is trust amounts. So it talks about the trust amounts. Essentially what the department has argued and the way they've applied this is that individuals over 65 can utilize these trusts, but they can't put any money into them. It doesn't really, why have a trust? Why would Congress create the ability of an individual of any age to utilize these types of trust, but then say you can't put money into it if you're over 65? It doesn't make sense. And if you look at subsection D, and D is sort of if we go back to 1993 when Congress put this into place, the purpose of this initially, this 1993 act, was to prevent, as you mentioned, people like Warren Buffett putting their money in irrevocable trust and then creating Medicaid ineligibility. Congress said, we don't want that to happen, but we do recognize that there are situations where individuals can and should be able to put monies into a trust, and here's the three types of trust that they should be able to utilize. One is the pooled trust. The other one that maybe you've heard of that's more as common is Miller Trust. So Congress specifically exempted those. If you look at subsection D, it talks about the fact that irrevocable trust and the money that gets put into them cannot create Medicaid ineligibility. So you can't do that.
But we're not talking about Medicaid ineligibility. We're talking about long-term care,
which is within Medicaid. So this all goes to Medicaid eligibility. The long-term care, it all is under the same section. There's not
I would
separate.
agree with you that if we were only looking at Section D, it seems like your situation would be strong, your case would be strong. Mm-hmm. But we're talking about C. And when I was reading the briefs, I did a word search for the long-term care in your brief, and I only found it in the introductory paragraph, one time for each plaintiff. And C is all over the place in the appellant or the appellee's brief. So help me understand, why are you not focusing on C? Because
the issue here is Medicaid eligibility generally. We don't believe that, we don't believe C applies because D captures the entirety of it. And so you don't have to look at C because D has already told us that the trust and the amounts in the trust are subject to this section, which means they're subject to not making an individual ineligible for Medicaid for utilizing that mechanism, as long as that trust meets those very specific requirements. It doesn't have to go to, you don't have to go to C, to subsection C. And if you look at the Beach case that we provided, it's part of the appendix. It's from the Tennessee Chancery Court in 2010. That case goes through very specifically why D only applies and C does not in a nearly identical situation in terms of what we're dealing with in terms of trust. And that is part of the appendix. We provided that in the appendix. What ultimately occurs here
does your argument make the under age 65 provision surplusage? Or I mean,
no.
Isn't our job to read them together, harmonize if possible, and give effect to both?
We believe that I think you're talking about the subpart C section that talks about putting money into a trust for somebody under 65. We believe that relates to third parties, so giving it, let's say, to your child. Let's say you're putting that money into one of these pooled trusts for your disabled child. That would not create an eligibility for you for long-term care or for Medicaid, because all of those items in C talk about going into giving to someone else, not giving to a trust that is set up for yourself. And the Beach case talks about the difference between this self-settled and and that's how they differentiate C and D in that particular case. The department, what's unusual about this is that the only way that the department says that this can be rectified is that the Coxes have to spend all the money that's in their trust. And this is where it leads to what I would call an absurd result. Everybody agrees that this trust should not be used as an accountable resource to prevent Mr. and Mrs. Cox from obtaining Medicaid coverage. But yet the department is saying you have to spend this resource that's not supposed to be counted against you in order to qualify for Medicaid coverage. We believe that under the statutes themselves, as well as the case law that we've presented from other cases, that at a minimum this court should require the department to engage in the fair market value analysis, and we believe that the facts here in this case show that there was a transfer for fair market value, even if this court agrees that the provisions of C apply. But again, we would ask that the court first find that only the provisions of D apply, and the funding of this trust itself did not create the Medicaid ineligibility.
Ms. Brommel, thank you.
Thank you.
Mr. Gillespie.
May it please the court, counsel. My name is Matthew Gillespie, and I represent the Iowa Department of Human Services. The question presented in this case is whether applicants for Medicaid long-term care services should be permitted to give away their interest in assets to pooled trusts without a corresponding penalty period beyond the narrow exceptions provided for by Congress. For the reasons stated in our brief and that we'll discuss today, the answer should be no. There are two big issues that I want to touch on here today. Number one being the distinction between paragraphs C and D under 42 U.S.C. 1396P and the calculation of fair market value. The distinction between paragraphs C and D is key to this case and has been blurred somewhat today and in briefing. 1396P sub C governs the transfers of assets for less than fair market value, and it only impacts a subset of services offered under the medical assistance program, being long-term care services. Whereas paragraph D pertains to the treatment of trusts for general Medicaid eligibility, which is a much broader scope than long-term care services specifically. D does not inherently affect the interpretation of paragraph C, nor does C inherently affect the interpretation of paragraph D. Appellants and Amici state their position that D is all-encompassing of all treatments of trust, including transfers for less than fair market value. But this requires the court to read in a limitation to C to avoid the exemption we're talking about today being surplusage. It requires the court to read into the limitation that C only applies to third-party trusts, as opposed to also being inclusive of self-settled trusts.
I actually think I'm with you on this distinction between C and D, but just from a matter of policy, why would Congress have cared? Why do they care? Why would this have been okay if the Coxes had been 64, but it's not okay if they're 67?
So,
what's the policy reason that may have motivated Congress?
Yes, Your Honor. Throughout the Social Security Act, Congress has designated that individuals at or over the age of 65 are aged. At the risk of prejudicing myself, it's Congress that made that determination, not me. But Congress made this determination, and as it relates to the specific exemption we're talking about today, it reflects a policy of preferring the preservation of assets for disabled Medicaid beneficiaries before they are of advanced age. They have typically by definition, a longer life expectancy. They're going to have higher needs over a longer period of time. And the policy is that before you are considered aged under the Social Security Act, that you have more access to your assets.
So if I understand what you're saying is, in effect, Congress felt it was more appropriate for people who were disabled and who were younger needed long-term care to be able to protect their assets than people who were older who had a lesser life expectancy.
Yes, Your Honor.
They expected them to maybe spend down.
Yes, Your Honor.
Instead of preserving the assets.
Exactly. And so the inverse of that being that if you are aged, you are expected to spend your assets for your own health care before asking for taxpayers to come in and step for that for you. And the limitation for long-term care services makes sense as well, because anyone that's dealt with nursing facilities know that these expenses are significant. And so Congress has delineated a narrow exception for when you can sort of shelter those assets. But if you are considered aged, Congress expects that you will spend your own funds. And so the issue of the limitation that the appellants urge us to read into paragraph C was directly addressed in Olson, and the Eighth Circuit directly refuted it and found, quote, that Congress intended transfers of pooled trusts to beneficiaries under the age of 65 to be subject to penalty. The second issue that I want to touch on here has to do with whether the transfer itself was for less than fair market value. It's our position that per se transfers to pooled trusts like this are for less than fair market value. But this is supported by a number of different concepts. Number one being that the fair market value of cash, unrestricted cash, is cash. And any restriction that you put on that cash to increase the illiquidity of that cash reduces its value. And if it's uncompensated, that by definition is a transfer for less than fair market value. Here, they transferred at the very least legal title to those funds, that over $500,000 in funds between the two appellants, for nothing in compensation. And this is acknowledged, the significance of this is acknowledged in the department's own rules. In Iowa Administrative Code 441-75.238, which is the definition of a transfer, the definition acknowledges this by defining a transfer to include, quote, transfers or assignments of any legal or equitable interest. And here, they gave away a legal title to those funds without receiving anything in return. Second of all, though, there is absolutely nothing in the record that shows that the trustees, under any circumstance, are obligated to pay a penny of what the appellants put into the trust. The beneficiaries, according to the trust documents, gave up their quote-unquote claim on the funds. The trustee holds ultimate discretion. In fact, the language is sole, complete, fettered discretion. And in fact, the trustee explicitly reserves the right to be unreasonable in the distribution of the funds. Regardless of this, though, and many of the cases that are cited, the administrative cases and the district court cases that are cited by the appellants, involve determinations where the trustee was obligated to expend funds on behalf of the beneficiaries. In this case, there was no such obligation. Regardless, however, it's another principle of fair market value that even if there was an obligation to make expenses over a period of time, the transfer would still be for less than fair market value, because the current value of cash, having cash now in your pocket, is still greater than the payment of that same amount of cash over a period of time. And in fact, they also gave away their ability to control what happens to the assets if they're not spent or transferred into different assets over their lifetime. They have no ability to determine whether it goes to their heirs and successors. And finally, the final reason why this transfer was per se, and as a matter of fact for less than fair market value, is that they're obligated to make fee payments to the trustees. And the fee payments for maintenance, ensuring the integrity and the compliance of the distributions with federal law, inure not only to the benefit of the appellants in this case, but also to the state. And yet the appellants are paying for the entire amount of the fees themselves. So by definition, in every way, these transfers to pooled trusts are transfers for less than fair market value.
Is there any need for additional or any fact-finding on the fair market value question?
No, Your Honor, I don't believe so. And I believe that the statute reflects this fact. It assumes, and the CMS letters that were cited in our brief, and the state Medicaid manual, and Olson, they all assume that these transfers are per se for less than fair market value. And they carve out an exception saying, okay, yes, transfers to pooled trusts when you're disabled and under the age of 65 are for less than fair market value. But out of public policy interests that we spoke about earlier, we're carving out an exception.
What deference or weight should we give to the CMS manual or the administrative rules?
The CMS manual, the state Medicaid manual, is entitled, I believe, to at least Skidmore deference. But there's some variation in how much deference that means. There's some case law that was cited that I don't have right in front of me this moment that specifies that when CMS opines on matters that are generally applicable as opposed to a specific question or specific case, that those are entitled to a higher level of deference. The same goes for the SSA program operation manual that was also cited.
But it wouldn't be Chevron deference because it's not formal rulemaking, right?
Correct, Your
It would
Honor.
be deference, but not that degree of deference.
Correct,
right?
Your Honor, yes. The other issue that played into fair market value today had to do with the value that is gained from continuing eligibility, which I just wanted to speak on for just a brief moment. It's important to note that Medicaid eligibility has no inherent fair market value. It certainly has some value, but Medicaid is an entitlement. By definition, there is not a market for it. It cannot be assigned a fair market value. But regardless, the statute was not intended to confer value for transfers that it meant to penalize and to limit delay eligibility for long-term care services. The letter cited from CMS, the state Medicaid manual, the statute, and many of the cases that were cited in this and the briefing all presume that transfers, that these transfers qualify as transfers for less than fair market value, and the circular argument that somehow the continuing eligibility creates some sort of value should be ignored here today. The last issue I wanted to touch on briefly pertains again to the distinction between C and D, because that's so important to the analysis here today. There are a couple provisions that were pointed out by Amici and the appellants where they seek to, again, kind of conflate this distinction, including the payback provisions and the function of that. And because this can get complicated even for someone who looks at this every day, I just want to lay that out there. The payback provisions in paragraph D4 make sense because they apply to all Medicaid expenditures, not just long-term care services. So, because again, D applies to Medicaid generally, D4 requires payback to the extent medical assistance is paid to the benefit of somebody who has one of these special needs trusts. So if you are on general Medicaid, and then later on you apply for long-term care services, well, you have a debt accruing by the Iowa Department of Human Services for the general Medicaid that you paid. And so if you die before all those funds in the trust are expended, then Medicaid has the right to collect on those funds under the Medicaid Act. And second, the issue with Miller trusts really does support our position here today. Miller trusts are, again, these trusts that allow individuals to assign income, usually when their income makes them ineligible for long-term care services. They're able to assign their income to a trust. That income is able then to be used for their supplemental needs. The state Medicaid manual explicitly states that the individual receives fair market value for the income that they assign, that they place to the Miller trust, only when it is paid out. And that same logic applies here today. If the income stays there, if they don't spend the money as soon as it comes in, as regularly as it comes in from the Miller trust, then those funds also incur a penalty period for a transfer for less than fair market value. But it's only when you make the expenditure that you receive the fair market value for those funds. And in fact, appellant's argument in this case presumes that they have not yet received fair market value. Their entire argument in support of them saying that they've received fair market value is this presumption that payments will be made at some time in the future for their benefit. Again, beyond the fact that there's no obligation for the trustee to do so, the presumption of payment in the future is inherently worth less than the current value of cash sitting in the bank or under your mattress today.
And consistent with that, the administrative law judge in this case ordered a recalculation of the penalty period for
Yes, Your
Mrs. Cox because some payments had been made already.
Yes, Your Honor, exactly. And that really does address the prejudice that's alleged by the appellants in this case. They have the opportunity to have the penalty period reduced once those funds are actually returned to them. And another policy interest that I want to touch on here real quick too is that under the state's analysis, this also means that the state is able to provide substantive oversight prior to making long-term care payments on behalf of the beneficiaries. If we adopted the appellant's position, we'd already be making payments for their benefit, for their long-term care services from the very start. And only after all the trust funds were spent would we have any opportunity to conduct any oversight as to whether those funds were spent properly, whether they were mishandled or whatever the case may be. Under the state's position, we give that oversight before we start paying any money because they have to show us that they received fair market value, that it was spent appropriately before we start paying for their long-term care services if the penalty period has not yet expired. And finally, just, I'm out of time here today. If there aren't any other questions, thank you for your time. We ask that you would please affirm the district court in this case. Thank you very much.
Mr. Gillespie, thank you as well. Ms. Brommel, rebuttal?
Thank you, Your Honor. I want to first start with Mr. Gillespie's statement that there's nothing in the record here that shows that the trustee is required to pay the trust funds for the benefit of Mr. and Mrs. Cox. That is absolutely untrue. There are numerous provisions which have been outlined in the briefs that require the trustee, and as a fiduciary, the trustee has that obligation to make payments from the trust that are solely for the benefit of the specific individual whose funds those are. It also requires that those funds be used only for items of fair market value. Also, I think it's incorrect for Mr. Gillespie to say that the department has no oversight on this trust at any point in time until later. These trusts are required to be filed and monitored by district courts. They're subject to reporting requirements. I believe the code section that it's under is 633C. I could be wrong about that, but there is a specific requirement that these be monitored, reported, so that the department does have an opportunity, the state does have an opportunity to determine whether the funds are being used in accordance with the trust documents and in accordance with the requirements of the statute. I want to specifically also bring up the Colorado case, which we filed as a notice of additional authority. That specific case, which was just decided in July, is Doe versus State Department of Healthcare Policy and Financing. In that case, the court did get to the fair market value argument, and basically the facts were similar to what we have here. Everyone had agreed that the trust was a valid pooled trust and could not be used as a countable resource. And then the ALJ, which the court then approved this decision, held that the spending plan, which is similar to what has been submitted in the record here, the Coxes completed with the help of their power of attorney, a spending plan indicating what items they believe the trust, in accordance with the trust documents, would be spent on. Also taking into account their life expectancy, which is 17 years for Mr. Cox and 20 years for Mrs. Cox. The court noted that the spending plan and the trust documents that required that the money be spent on their behalf was the credible evidence that there had been full and fair consideration received for the transferred funds. It also noted that those trust documents, similar to what we have here, restricted the trustee's discretion and were sufficiently binding to constitute fair consideration. The court also addressed the argument that's been made in terms of whether that money has to be spent now or later. And the court found that fair market value does not require a full and immediate exchange of value, because such an argument would mean that no trust could ever meet those requirements, because by definition a trust exists in order to provide future care and support. One of the items that's been brought up by the department is the 2008 CMS memo. And I think it's very important to realize that that memo does not say the same thing that their state Medicaid manual says. It does not say that by placing money in the trust after age 65, you are absolutely per se automatically ineligible. What it says is that the individual may or may not be eligible, or may not constitute a fair market value. It specifically calls for then a case-by-case analysis of that fair market value. The CMS memo itself does not create that per se. It does, there are some documents that reference, that generally there will not be, it is not a fair market value, but it specifically says it may or may not be a fair market value. And I think the Kansas case that's been was issued in 2017, Hudson versus Mosier, that case specifically found that this fair market value analysis is a factual analysis, and the court remanded because there wasn't evidence in that case that analysis had occurred, nor was there evidence presented regarding the fair market value.
Hypothetically, if we remanded for a factual determination of fair market value, what additional information beyond what's in this record would be examined?
I actually don't believe that it needs to be remanded. I believe that all the information exists in this record. What the department has said is we don't have to look at that it's just automatically not a fair market value. But if you look at all of the cases that have determined that fair market value did occur in these types of deposits or transfers into the trust, the court looked at the same exact factors. They looked at the spending plan, the trust documents. They believed that those sufficiently established. They also looked at what had the trust up to that point been spent on.
You're asking us, obviously, to second guess the DHS determination there was no fair market value.
They did not even analyze that because they said per se. We believe that the facts are there, that yes, that there's substantial evidence in the record that shows they should have made the determination that a fair market value transfer existed.
Is there substantial evidence in the record to support the contrary finding that there was less than fair market value?
No, the department offered no evidence. They did not attack the evidence. They simply said it's a per se decision. We don't have to get there. If you look at the transcript of the contested case proceeding, I asked both of the department workers, did you look at fair market value? They both said no. We read this one line in our manual that says it's not, and that's all we did. And they presented nothing to show that our information was incorrect or that it did not constitute fair market value. I think my time is up. Thank you, and we ask that you reverse the decision of the district court.
Ms. Brommel, thank you as well. Mr. Gillespie, thank you again. The case of Cox versus Department of Human Services is now then submitted, and I'll ask the bailiff to adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.